Hello, my name is Barry Arrington, and I'm the Chief Legal Counsel for the National Association for Gun Rights. And we are in the middle, episode 2 of 3, of a 3-part series on legal worldviews and how they impact the Second Amendment and the right to keep and bear arms. And people think, oh, whoa, legal worldview is philosophy. That's just so arid and dry. No, it's fundamental, because the difference between the legal worldviews is the difference between Justice Scalia's majority opinion in Heller and Justice Breyer's dissenting opinion in Heller. And if you don't understand that difference, you don't really understand Second Amendment law. So let's get into episode 2, Holmes and his disciples. So in our last episode, we talked about how in the founding generation, the law, writ large, was based upon a conception of the English common law. And the English common law was largely based upon William Blackstone's commentaries. It is no exaggeration to say that it was the most influential legal treatise by a wide margin in the 18th and 19th century, and it had a profound impact on the founders' view of the law, so much so that if you read Blackstone's commentaries and you read the Declaration of Independence, some aspects of it seem to be tracking with one another. And the reason for that is that both of them are based upon a Lockean view of men are endowed by their Creator with certain unalienable rights. And Jefferson in the Declaration was quoting Locke, and Blackstone, in his treatise on English common law, his commentaries, was also quoting Locke from time to time for the very same aspects, that the 3 big absolute rights of the natural law are the right to life, the right to liberty, and the right to property, which kind of got transmogrified to the pursuit of happiness. So that was the founders' view of law. Well, what is the modern view, and how did it originate? Interestingly enough, the modern view of law had nothing to do with law. You ask, how is it possible that the law was so profoundly influenced by a non-legal source? And the answer is relatively simple. From the founding period forward into the 19th century, the 1800s, Blackstone's view, which was the view of the founders, that the law is transcendent, that it's out there, it's to be discovered, that it's based upon fundamental moral principles, held sway. That view began to crumble in the second half of the 19th century. And the reason that view began to crumble can be traced very clearly to a single book. In 1859, Charles Darwin published An Origin of Species. That book captured the Victorian imagination in a very profound way. In the last half of the 1800s, a lot of folks were saying, well, prior to Darwin, we had Hume, but he was just kind of a philosopher. But now Darwin has given us a scientific basis for jettisoning morality, that we don't have to have a God to have created everything and to have imposed a natural order, and Darwin has proved it. Now, whether he did prove that or not is a separate question that I'm not going to get into, but that's what was thought. Richard Dawkins, as a matter of fact, said you could be an atheist prior to Darwin, and Hume was, and his grandfather Erasmus Darwin was, but according to Dawkins, you could not be an intellectually fulfilled atheist until after Darwin. And so what does that have to do with American law and the right to keep and bear arms? It has everything to do with it. How so? In 1897, enter one Oliver Wendell Holmes Jr., who at the time was on the Massachusetts Supreme Court, and later, as we all know, was elected to the United States Supreme Court. And it is no exaggeration to say that Oliver Wendell Holmes Jr. had the most profound impact of any single figure in the last 150 years on American law. 1897, as I mentioned, was a critical date. And what was critical about that? That was the date Holmes published his seminal article in Harvard Law Review called the path of the law. And I won't get into all the ins and outs of the path of the law, but the main thrust of the article and what Holmes was getting at was that we're all grown-ups now, scientifically speaking. And we can't really talk about morality as some transcendent thing that's out there. That doesn't exist. And so what he said in the path of the law was very, very interesting from a historical perspective because it had a profound impact. For my own part, I doubt whether it would be a gain if every word of moral significance could be banished from the law altogether. Holmes advocated that every word of moral significance be banned from the law altogether. What did he mean by that? Well, Holmes' worldview was profoundly influenced by Darwin, and Darwin in the Victorian era, there is no transcendent morality. There's just particles in motion, materialism, if you were. And Holmes said, we've got to come to grips with this, and have our jurisprudence conform to reality instead of hopeful, wishful thinking, like the founders did. And so how do we know that Holmes was so profoundly influenced by the scientific materialism of his day? And what did that mean to him? Well, I've got a few quotes from Oliver Wendell Holmes. The first quote directly links his views of the law with Darwin. In a letter to Harold Lasky, I think morality is a sort of higher politeness that stands between us and the ultimate fact, force. Nor do I see how a believer in any kind of evolution can get a higher formula than organic fitness at the given moment. Basically, he's saying it's the law of the jungle out there, survival of the fittest. That applies not just in the animal kingdom, it applies to humans as well. Why? Because we're part of the animal kingdom. We're just jumped up, hairless apes who think that we're pretty clever. And we have this delusion that there's some morality out there that is transcendent, timeless, fundamental. Well, that is something that we just have to jettison in our worldview, according to Holmes. What did that mean for Holmes? Well, I'll give you some other quotes from Oliver Wendell Holmes. You respect the rights of man? I don't, except those things a given crowd will fight for. What does that mean? Holmes recognized that we live in a jungle of tribe against tribe, a war of one against all and all against one, and that the only thing that settles our differences is force, but we do have this kind of higher politeness of law that we can sometimes interject to try to fool people into behaving themselves. That's basically his worldview. What about natural rights or the rights of man? You know, the Declaration of Independence says we hold these truths to be self-evident. They were self-evident to Blackstone. They were self-evident to the founders. That there are certain natural rights endowed by the Creator unto man. They're inalienable. The right to life, the right to liberty, the right to the pursuit of happiness, or in Blackstone's formulation, property. Well, what does Holmes say? All my life, I have sneered at the natural rights of man. Holmes didn't believe in natural rights. He utterly rejected the founding principles upon which the Declaration was based. What about, how did this, why was he so adamant in his view that natural rights don't exist? Because he was a thoroughgoing materialist. How do we know that? Again, another letter. I see no reason for attributing to man a significance different in kind from that which belongs to a baboon or to a grain of sand. What is the materialist worldview? And when I talk about materialist, I don't mean materialism, the pursuit of things and shopping and all that sort of thing. It's a philosophical proposition that Holmes subscribed to, that there is nothing in the world, nothing in the universe other than particles in motion, that there's no spiritual significance. Above all, there's no God, there's no angels, there's no demons, there's no devil. That's just material particles in motion and brute fact. And that means that at a very fundamental level, according to Holmes, we're no different from a baboon Matter of fact, we're no different from a grain of sand. We're all just made of material stuff. And so when I said that Holmes conceived of us as jumped up, hairless apes earlier, I wasn't exaggerating. That's how he conceived of us. And that's how he interpreted his role as a judge and how he was trying to move the law away from what he believed was a fantasy of objective morality towards the reality that there is no morality, there's only force. There's only tribalism. There's only who can kill more effectively. Well, that's pretty harsh. Did he really say something like that? Well, let's take a look. This is chilling. When men differ in taste as to the kind of world they want, the only thing to do is go to the work of killing. Holmes really did believe that force was the ultimate arbiter of differences, and that the law was just kind of a mask of, a higher politeness, that maybe it stopped the application of force, and that would be kind of good most of the time. And maybe it didn't. And if it didn't, okay, we just start killing each other. And then whoever kills the most wins. That was his view. How did this affect his judicial temperament? Well, for one thing, he was a thoroughgoing eugenicist. Eugenics, the science, the so-called science of improving the human race through various means, including forced sterilization. Holmes, applying his materialist worldview in the famous case of Buck v. Bell, said 3 generations of imbeciles is enough. And why is that important? Because he was upholding the constitutionality of a state statute that allowed for the forced sterilization of people deemed mentally unfit. And of course, that's no longer the law today, thankfully. Holmes' most famous decision has been overturned. Holmes' view was very, very harsh. And you would say, well, that's immoral. To which Holmes responded, there's no such thing as immorality. There's only power. There's only force. And that is the worldview that got launched at the beginning of the 20th century by Oliver Wendell Holmes. And how has that influenced the world today? Well, beginning early in the 20th century and then accelerating as the century progressed, there came to be a jurisprudence known as legal realism. Why legal realism? Well, Holmes would say that law based upon morality is legal fantasy. Legal realism, on the other hand, is based upon the way the world really is. There's no morality in an objective sense. Critical legal theory is just what you expect it would be as a subset of critical theory. The theorists reject all notions of transcendent moral good. There is no such thing in an objective sense. Yes, we have subjective morality, which is what evolution has foisted upon our genes as a survival mechanism to cause us to prefer certain things. But that's just another material cause. It doesn't have anything to do with morality that's out there that to get discovered. And so since there's no transcendent morality, what does that do in terms of our relations with one another? If there is no transcendent intersubjective rule that governs you and me, how do we resolve disputes? And the critical legal theory says power. Everything devolves to power. Those who have it, those who are exploited by it. If everything devolves down to power, every aspect of our lives, including politics, including law, including religion, including basic moral norms, is just a outgrowth of oppressors inflicting their will on the oppressed. And if we approach a text, especially a constitutional text, with the presupposition that there are no transcendent moral norms, that the universe is just particles in motion, and that all disputes are ultimately resolved by force of one tribe against another, how does that impact our resolution of a constitutional dispute, especially a constitutional dispute about the right to keep and bear arms? Well, that's what we'll find out in the next episode. Thank you very much for tuning in.